Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
so
understand.
I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7. Within that 7 are included. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
Sleep early
Test, and he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I saw it. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh, my God.
Your Honor, may we discuss setting a new bond for
Of course.
Oh, my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh, my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white, and Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But fine, because.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One. After. Yep.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand that.
a 0.1 mile away from the location.
So-
For what?
Well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it. Because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Let's pull up the code.
Intake could have taken some other things, but.
Well, certainly they could have taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
But they didn't hit. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can. It's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. No. So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so that the cop can claim anything is interfering with public duties.
I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described.
They put him.
the
I guess did they put him under arrest at the time when he said that he was making that threat?
And with being.
I mean, did they have the authority to arrest at that time? Right.
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the misclaim.
And it's at that point they start to put him under arrest.
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's
I
a
mean,
resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but so.
I mean, we don't know. I mean,
Okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report yet.
We don't
I
Judge.
don't care. I mean,
He was in
but
the
I think that
process.
there's enough. He places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
No, I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with.
Remember-
Right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt. Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then
The
address
bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it. They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. Yeah, give me a second.
She sent me an email from one of
If
the.
anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I have an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to the class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have nothing.
Tell me, what have you done?
I went to the class.
Okay. Which class did you go to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining on how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number because I'd like to call them right now.
I have a number for you, Judge.
I'm going to put this on.
Charles Jackson.
Hello? Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, it allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a progress education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depending on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know. I'm kidding.
No, I understand that.
She's been faithfully attending, though. Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay. So I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying. If you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You
okay. You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. I don't give bonds 2 times in a row. And I counsel people every single time when they come here that if I give you a bond now, it's not going to happen.
They put me on insulin. I take insulin 2 times a day. I can't, the way that they expedite you there, I'll be sick by the time I'm done. Please.
Giving them 1. I can't do it again. I'm bish. Mr. Berry, we're bringing you out now because your lawyer has asked for me to set you a bond.
Yes, sir.
I don't know. I've got 2 main concerns. First, most importantly, are you a danger to my public? And number 2, equally as important, are you going to go back to the jurisdiction you're wanted from?
Just wait.
I'll give you a chance. I know that you're going to tell me that it's gumdrops and rainbows and I get it.
Sir.
But the way that I get to know you is how you look on paper, because that tells me who you are.
Sir.
Not what's in here, because a lot of people tell me things, and when they walk out the door, they turn into someone completely different.
Sir.
And so that will really tell me who you are.
Sir.
Okay. I will give you the opportunity to speak. I'm going to give her the opportunity to speak as well. I'd like to know, number one, where is he wanted from, what for, and what kind of priors does he have?
Yes, Judge. He's wanted out of Fulton County, Georgia. On the front cover of the fugitive page, it states that he's wanted for theft of taking, but I did a little bit of digging, and it looks like he's wanted for 4 felonies out of the same transaction. I don't know why they didn't include it on the teletype or running his FBI number confirmed. He's wanted additionally for second-degree felony criminal damage to property and two charges for unlawful person employed by or associated with criminal street gang to conduct and participate in criminal activity through commission of offense. It's a very, very long charge name. But it looks like it was the same offenses that he was originally extradited for back in 2022. I guess he either absconded or violated them again, but it looks to be open cases. And specifically addressing bond is that the state would be opposed for him granting a bond. In the past 10 years alone, not excluding other states and anything past that, he's been arrested 21 times, 12 of them felonies, 2 revocations of paroles, and 3 evadings, 2 felonies and 1 misdemeanor. I believe he's a definition of a flight and safety risk, and due to that fact, we request that the court deny bond.
Your Honor, if I may. So in regards to the telegram, because obviously the state has their duty, I have my duty as defense attorney. All of the other charges that were not on that telegram were dismissed. The case was reduced to theft. This case has been pending since God knows when, because Fulton County is a very slow court. Your Honor, here as I stand with the same client, I stood before you 2 years ago asking for a bond for my client to go back. You granted a bond, Your Honor. And when you granted that bond, my client did what you would want anyone to do, which is turn himself in, appear in court. They gave him another court date. However, no, once he checked himself in, he was able to bond out of Fulton County. Since then, that case has still been pending. He has an attorney in that county as well. However, throughout the times, my client moved. The issue was that there was supposed to be an updated address change to the court. So there was a court date, I believe around August the 12th. And because they did not update his address, the notice was sent to his old address. They immediately issued a warrant. So my client was actually picked up when he came back from work. He didn't even know that he had a warrant. And I understand the state's position that my client does have an extensive history. I was also his parole attorney, which he was successfully discharged from as well. I know Mr. Berry, and I could stand for him before this court. Anybody that I have stood before you has always, I'm not gonna take a client that's gonna embarrass me or embarrass you. He came, last time you allowed and granted a bond, he did exactly what he's supposed to do. And if you do it this time, he would do that again.
I don't give bonds 2 times in a row. And I counsel people every single time when they come here that if I give you a bond now, it's not going to happen again. It's your responsibility. You've been a fugitive once. We don't let you do it over and over and over. I gave you a bond last time. I can't keep doing it because you're going to keep, it's the same thing's going to keep happening.
It's not, sir. I promise you.
I get it, but it did. And I told you last time, but it's not going to happen again.
Yes, sir. Can I talk to you, please?
But Your Honor, it was not, so this.
How do I know that?
So I'm telling you this because I'm also an officer of the court and I've done my research, Your Honor. It was not his fault. It was not. It was just a mistake of address. That's the only reason why. I've been checking in with my client.
He's supposed to update them of any changes.
For that part. Can I please talk to you, please?
So what I would do is reach out to Fulton County, let them know, and hopefully they'll pull the warrant. They'll pull the hold. Or will they not?
So, Your Honor, I've had history with this county. They're very slow.
Yes.
It's very difficult.
Have you done work there?
Huh?
You've done work there?
For other clients.
Really?
Yes. Your Honor, can you just listen? Can you just hear him out as to
I'm
why?
happy to hear you. Please.
So with the regarding that you did update your address,
yes.
Typically address that.
Yes. Your Honor, the last time you gave me this bond, you told me to get a job and you told me to change my life. And I did that. I completed CDL school. I work every day.
Wonderful.
They put me on insulin. I take insulin 2 times a day. I can't, the way that they expedite you there, I'll be sick by the time I make it. My flight has already been the process of being booked, like you told me to left.
Can't take a flight.
To turn myself in?
Mm-mm. You have a warrant. If you try to get on an airplane, they're going to take you into custody.
They let me last time. You let me out. They let me take it. I turned. Okay, the address I updated it, Your Honor. And
how do I know that?
I mean, I didn't.
I'm not supposed to take your word for it.
I was honest with you last time about everything.
And that's why I gave you a bond. And I told you though the last time it's not going to happen again.
But you said if I messed up, and I did not mess up, Your Honor. I did good, Your Honor. I
Great.
promise you.
But now
You
something,
gave me 10 days to turn myself in. I turned myself in 6 days.
Your Honor, it was really because of the address change. And
Please, Your
So
Honor.
if you're not going to at least believe him, you can hopefully.
it's not a matter of belief or disbelief.
Okay.
It's a matter of that we cannot continue to enable. That's what it is. And if I do this now, who's to say it's not going to happen a third time?
It's not, Your Honor.
because-
Told me
They
that the
dismissed
first
my
time.
cases.
They
They dismissed
so-
3 of the cases, Your
So
Honor.
from the time of this charge was pending, 3 of those cases were dismissed, Your Honor, and then the other cases were dismissed at that. Clearly, the
Yes,
reason
sir.
why it's pending is because they don't have anything, but it's not.
So what? I mean, can't you do a speedy trial? Ask for a speedy trial.
So he has an attorney on that court. It's just the court's very slow and it's very different.
But
Yes,
what
Your
I
Honor.
can assure you is, it was just a mere mistake, Your Honor. Like,
So I just want to
Please,
step in
John.
real quick because I've had one before where they stated it was a clerical error, and I want to say only one time out of all the other times I approached where it was a genuine clerical error. Once they corrected it in the demanding jurisdiction, is they removed the warrant. I've had that happen before. So if the court wants to roll it over for a day, and if counsel wants to contact Fulton County to figure out if it was truly a clerical error and it was a misunderstanding of where it was to be shipped out for
But I
notice.
think what they're saying is that there was a problem where he's saying that he updated the address, but they didn't do it.
Sure, and that's what I mean, is if there was an error, right, with the court in
And
Fulton
reach out
County.
to them and see if that's the case.
well,
You can Google it, Your Honor. It was a glitch in Atlanta's.
Let me ask you this, Mr. Berry, how did you update your address?
I called a bond company. That's what they entrusted me to do.
Update it, right? No.
Well, so I don't really talk for their system, but that's what I mean, is if it's a mistake on the court, right, and not the defendant.
What I would do is get into contact with the bail bond company and say, hey, man, this is what we did. You didn't do it the right way. We're gonna, if you don't fix this, there's a bail bond board that you can report activities to in the event that they mess up.
Sir, yes, sir. Please.
I've given them one. I can't do it again. I never do, ever.
3 days and I'll be there.
Well, and it is also worth noting, it's probably good to update on the front end because he's on a deferred in our county before they revoke, because there was a warrant issued out.
It's also on deferred here?
He is.
For what?
For possession of controlled substance.
A list in the ground.
So, but the fact that he's open on deferred and no one has filed a motion to revoke, because initially all they see is the capias issued on August 15th. They haven't filed a motion yet, but that's my point, is before anything else happens, if counsel does want to correct it for both reasons, for the extradition and for the local deferred, it's probably 2 birds, 1 stone to call Fulton County and figure out what happened with the court there.
Try that.
can we roll it tomorrow?
Yes, absolutely. Of course. I would reach out to the bonding company, say, hey, man, I did this. You guys messed up. Fix this. Otherwise, we can file a complaint. You're telling me you did. If you did, then that's the right thing to do.
I mean, I'm begging you, sir. I'm insulin independent now, and life has changed for me. I know I got in trouble in the past, but you instructed me to do something, and I done it step by step. I changed my life, everything, Your Honor. And sir,
the entire time I've been here, I've never once given a second bond.
So, Your Honor, if I may, if we do
Sure.
get information.
I will never say no, but I don't know. I mean,
Well, I'd rather take I don't know than no. So.
right. I don't know. I don't know. I never want to say no, because you never know what someone else is going to provide you to show you that really it's not his fault. And if it's not, then,
Like I said, I've had it happen before where the court demanding
if
jurisdiction.
it's really not his fault, would you then post?
please.
No, but please don't beg.
Yes.
Because last time we went in, you don't.
Yeah,
Let's see what they have. Let's go from there. And I don't want to commit you to an answer. That's really not fair.
Yeah,
So-
and in the spirit of transparency, I do show that he hasn't had any violations since he entered in the deferred, because it was concurrent with dismissal of the others.
Yes.
So other than this, there have been no other violations. It was September of 2022, but it's just with the sheer amount of history, because it's one of the longest I've seen, that's my concern. And
Saying he's been doing good.
well, that's what, so.
He's been doing very good.
Right, so that's
Everything's
what I mean.
early termination for me, sir.
So that's the thing. It's just
Okay.
please.
So I want information from the court, because ultimately in the end, it's not whether, it's not the how they prosecute the case is whether he's wanted and whether the KBS is true.
Diligence,
So-
let me see what you got and let's talk.
Okay, we can.
I'm never gonna, well, I'm not saying never because I always put my foot in my mouth, but let's see what, and we can regroup. Okay?
Thank you.
All right, Mr. Barry.
I'll see you tomorrow.